just want to clarify on one issue that probably Lop raised. The decision, the issue of the position of the inmates now, all the inmates who are under the trial in the General Court Martial, all their matters are now under the jurisdiction of the courts of judicature.
Just wait, Attorney General.
Yes.
Kindly, honorable colleague, take your seat. Attorney General, continue.
Yes. So what I'm saying is that the court said seize these matters and transfer them to us. That means that the court, the Supreme Court, handed the jurisdiction over any matter that relates to any of those people to the courts of judicature. Now, Honorable Ssegona, we can continue the debate. I have rendered advice. I have told you that the government has decided to comply with the court orders, and we are going to comply with the court orders as have been given by the Supreme Court. I thank you.
Thank you, Mr. Speaker. Mr. Speaker, first, I think as the Shadow Minister for Justice, I would like to convey words of acknowledgement and appreciation to the justices of the Supreme Court for coming out very clearly and boldly in delivering this judgment, which had caused great concern amongst the public and some sorts of anxiety. So I would like to thank the judiciary, the Chief Justice, and the justices who delivered this unanimous decision. Mr. Speaker, Article 126, Clause 2E, and I would like to read, says that substantive justice shall be administered without undue regard to technicalities. The learned Attorney General understands this very well. What he's trying to do is trying to delay substantive justice. The orders are as clear, and that court-martial, in my understanding, has not been disbanded. What I'd expected today or yesterday was for the court-martial to sit and say, we are now discharging all these persons that were before us, that at that time we thought we had the authority to try them. But now that court has declared we are now discharging them. And that would be the most logical step to do. We also know that courts rely on departments and agencies and authorities of government to function. Courts do not have the force to go and pick people, just like the speaker you observed here. As parliament, we cannot go to prisons and open those padlocks. Courts rely on the goodwill of the executive in implementing the decisions that they issue. So I expected that the Attorney General, the DPP, the Commissioner General of Prisons, whoever is involved, to comply with this. The last point I would like to ask the Attorney General. You have read to us very good advice you have rendered. I would like to know whether you rendered that advice to the President. The President quoted you, that he called you on phone, and you seem to have given him an advice that does not match with what you are telling us here. Would you now? And Mr. Speaker, this letter from the President is in the open. I don't need to go through it. But he quoted that he got in touch with the Attorney General, who explained to him certain things. I understand that the Attorney General, being a party to the suit at that time in the heat of the moment, having lost that big case, you would have lost a little bit of your composure. But would you now clarify to us? And I've ever been to the Supreme Court as a litigant, and I lost a case. I know what it feels like. So I understand what the Attorney General went through. But would the Attorney General tell us clearly if this advice that he has told us here is exactly what he rendered to the head of the state? Because what the President wrote potentially undermines the rule of law, undermines democracy, And I thought that it is incumbent upon the Attorney General to guide the President on the next course of action. Would you clarify to us and even lay, where possible, that opinion? Because this is not just advice. You said a legal opinion, and there is clarity on how a legal opinion is rendered. Would we see that here, Mr. Speaker?
Thank you, colleagues in the public gallery this afternoon. We have students from Hatumbanja Child and Youth Development Center, Namaingo South County, Namaingo District. They are represented in Parliament by Honorable Wanyama Michael Dori and Honorable Makoa Margaret. They've come to observe proceedings of this House. Please join me in welcoming them. The Honorable Attorney General. Narrate the
Thank you
Attorney
very
General,
much.
please. Answer some questions.
Thank you
then
very much, Right Honorable
I can
Speaker.
pick another set, okay?
Thank you very much, Right Honorable Speaker. First of all, the court martial cannot sit. So it cannot sit to make any orders that you want them to make. That's one. Number two, if there are facts that you have, Honorable Medad Ssegona, as a senior lawyer, if there are facts like you have stated here, the best place to take them is to the court. Yeah? Yes. Secondly, Right Honorable Speaker and Honorable colleagues, Honorable Ssegona should know that as a practicing advocate, after you are successful in court, you extract a decree. If you think my advice is inconsistent with what the judgment said, you should at liberty to extract a decree, have the court sign it, and use it in the premises that you would like to use it. I have read this judgment variously, and you may think that I was sleeping. I did not. I spent time reading this judgment page by page, and I word for word. And what I have advised here, I did not get from my head. I got from the judgment. The matter under discussion is not the Court of Appeal decision. The matter under discussion is the Supreme Court decision. Was appealed against is misplaced. Now, there are no timelines. I agree. But we have sent the matters to the courts which granted these orders. The courts are still clothed with the authority to make any orders that they deem appropriate. Like
Point of order.
You see, Right Honorable Speaker, when the Attorney General speaks, he's the head of the bar. Everybody at the bar ordinarily should keep quiet. I agree with him that a successful litigant goes ahead together with the losing litigant to sign a decree, to prepare a decree jointly. If he was waiting for a decree, what was the basis of his advice? Number two, I am not aware, and he can now educate us, the law under which a losing or vanquished litigant would write to court to ask for which orders. The orders, Honorable Nwagaba says, is self-executing. Is the Attorney General, therefore, in order to mislead both the House and the country that the person who was in court when the judgment was being issued is waiting for a decree extracted by one party?
Attorney General, want to make some clarification, if I can guide?
Right Honorable Speaker, I think where we are going here is a bit of a runaround, because I have told you my understanding of the judgment. And yes, and that's why maybe I lost. But what we are saying is that if you disagree with what I have written as what the court said, the arbiter is there. Now, finally, Right Honorable Speaker.
Procedure, Honorable Seshkuba. Procedure.
Thank you very much, Right Honorable Speaker. and members. Right Honorable Speaker, as a law student and a practitioner, the basic principle we are taught and we learn and we practice is that judgments of court, particularly the Supreme Court, are judgments in rem. They are not in personam. Meaning that all must abide not only the Attorney General, but the constitutional order in the country must listen and adhere. So, number two, the Land Attorney General, Right Honorable Speaker, did his best when he made arguments before the Supreme Court. He did his best. That is the best he could offer. Now for this House to demand and to expect a better alternative from him, I think would be too much. That is the best he could offer. He stayed the Constitutional Court order. He ran to the Supreme Court, prepared himself, robed himself, got all his entourage with wheels and cattle. He proceeded to the Supreme Court. Unfortunately, he couldn't do better than he did in the Constitutional Court.
What is the
To that regard, Right Honorable Speaker.
I need the procedure matter.
Yes. For this House to expect a procedural guidance from the Land Attorney General, when he had failed to convince the 7 justices of the Supreme Court, Mr. Speaker, sir, would be a big disservice, not only to this country, but to Parliament. And lastly, Mr. Speaker, I listened in very well. Once you talk about the Constitution, it is the paramount and the fundamental law we have. In his statement, I heard him say that the DPP, the Director of Public Prosecutions, should liaise with the General Court Martial to get files and process those files. Right, Honorable Speaker, for purposes of record and the Hansard of this House, Article 120 of the Constitution is the Director of Public Prosecutions. And Clause 6 states, in the exercise of the functions conferred on him or her by this article, the Director of Public Prosecutions shall not be subject to the direction or control of any person or authority. By the Land Attorney General telling the DPP to go and liaise with the General Court Martial is in total breach of this Constitution. And I would therefore like to say that his guidance, even now, is continuing to offend this Constitution. And therefore, I would pray that we give him leave so that he can rest, he can think about the events of this country, he can choose whether he wants to take the country the constitutional path or he wants to take this country in the dark times, and without any delay, comply with the Constitution, with the Supreme Court orders, and release these persons detained, so that now the country can breathe a sigh of relief. Without that, whatever explanation is talking about, he's wasting the time of this House and is continuing to agonize the constitutional order of this country. And I pray that anymore, Mr. Speaker, sir.
Thank you. Now, just wait, Attorney General.
Thank you.
Just wait. Honorable, now, to begin with, I think we had started well, appreciating each other, both sides, in terms of the swift action that the Attorney General had taken. He told you immediately how he moved. Even on Sunday he was working, even yesterday he was working. So I think that was in the right direction. Now, where we are disagreeing is the content of what maybe he has written and what he has not written. And when I was listening on the issue of the DPP, and I would want it to be very clear, I heard you using the word I advise. I heard it several times, I advised. So meaning if the DPP still has a discretion of taking the advice or not taking it. So that's what I was hearing. I think, honorable colleagues, also when we say the Attorney General has guided the House wrong or what. We are not making any resolution on this matter. I asked the Attorney General to give us an update. This is a matter which has been settled by court. We cannot reopen it here. We just needed an update on how far he has reached in as far as implementing the court order is concerned, because honorable colleagues are raising this issue. We don't expect any other any other decision here that is going to override the decision of the Supreme Court. Attorney General, allow me to pick Honorable Okror, Bosco, and Honorable Fox Odoi. Now I need to balance sides. Me first. You rushed to give information. You are fearing banning Honorable Okror.
I want to sincerely thank you, Right Honorable Speaker. I think I want to make a humble contribution to this discussion. Right Honorable Speaker, the judgment of court was pronounced. I think the most unfortunate thing that some of us are doing is thinking that we can read this judgment off from the original text. We have excerpts of judgments which people are reading and not understanding the exact judgment. Yes, you can say the pronouncement of court that judgments of this nature are in rem. It is true. But even for you to find somebody in contempt, one of the executing officers, it ought to have been brought to the attention of that person. We have the judgment which has been delivered by court. But what can only be executed is an extract of a decree or an order, which is the responsibility of the lawyers who are participating in the case. So, Right Honorable Speaker, we can say they are self-executing judgments. That is right. But when you read the orders of this judgment, and I want to particularly look at one of the orders, it says that all charges, this is the judgment of Winyidolo, all charges, page 194, all charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with the competent jurisdiction. The word immediate is there. It's immediately cease and be transferred. So when you are reading the text, the paragraph, the sentence, it has a continuing. So if you say, this is a matter of interpretation. And where there is a dispute, as per the interpretation, it is not for Attorney General, it's for the court to settle that component. That what do you mean? Because court did not say release. If we are reading it to the dot, the court did not say release. Say immediately cease and transfer. Now, the process of transfer is a process. It is a process. So I think we need to understand it from that context. So we cannot castigate Attorney General for giving his view and all the processes that are being undertaken. But I think let's do our work. This is the real text. I beg to submit.
Thank you, Honorable Fox Odoi.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker.
Order, Honorable colleagues.
Right Honorable Speaker, I will take you back in time. Take you back in time to a language that is now considered dead. This language used to be the language of instruction to lawyers. It is otherwise known as Latin. In Latin, we would summarize our discussion this afternoon in one sentence. Corte suprema alacuta cosa finito. And I will translate that. The Supreme Court has spoken, all matters are settled. There's no matter left for discussion. There's absolutely nothing left for discussion. there's absolutely nothing left for resolution. There's nothing left for amendment. Even here, I understood the position of the Speaker to be a request to the learned Attorney General to render an account of the implementation of the court order. And I sat here attentively and I listened to the learned Attorney General render an account of the steps they have taken to implement the court order in an orderly manner. Because we do not expect them to implement the court order in a manner that will cause chaos. They will never be able to amend a single order from the Supreme Court. So, and he's only pleading for time. He's asking you for time to implement the court order. My land brother Kiryowa has already told you, even where the court said there must be cessation of prosecution immediately.
Point of order. Honorable Chair.
Thank you so much, Right Honourable Speaker. Right Honourable Speaker, the Honourable Fox Odoi is the chair of the Human Rights Committee. He is supposed to help protect the rights of Ugandans. He knows that people who are now in prison are detained illegally and their rights are being infringed upon. Is he in order to say that what the Attorney General is doing is okay and people can be in prison and wait because he's doing it orderly? Is he in order?
Now, honorable colleagues, how will I be determining points of order on opinions? Because these are opinions. This is Honorable Fox Odoi's opinion. This is how he has understood it. Now, where will I bias myself? Say, for you, you're out of order. Your opinion is out of order. It becomes difficult for me. That's Honorable.
Thank you very much, Right Honorable Speaker, for your very wise counsel and ruling. Right Honorable Speaker, the Attorney General is in a very unenviable position. And at this very critical moment, I can only state that I have absolute faith in his knowledge of the law and his commitment to actions bona fides. So as a House, Right Honorable Speaker, I think it would be improper for us to impute malified intentions on the part of the Attorney General. I beg to submit.
Thank you. I had allowed Honorable Ssemujju as we were beginning.
Mr. Speaker, I want to thank you very much. The Attorney General has said the court martial cannot sit because of this judgment. For the court martial, they are not waiting for a decree. There are also no discussion with anyone else, but they immediately stopped functioning. And I want to thank him for release of prisoners, including Dr. Wesigi, who is in Iruzira now illegally because there is no detention warrant. There, the DPP is realizing I have written to Supreme Court. Why didn't you render the same advice to the court martial that continue working as I liaise with the Supreme Court? Why do you think for them they needed to stop functioning immediately, but the others can continue disobeying? I am sympathetic to him. Maybe the same reason that court said military people cannot purport to be dispensing justice. Because the people were asking the Attorney General to advise, they have already expressed themselves. The CDF said Wesigi can only get out of prison in a coffin. Really, what sort of advice can you give a person who thinks like that? even if you are a professor of law times 3. The CDF, one of the supervisors of the General Court Martial, has said Dr. Westje can only get out of prison in a coffin. He had even arranged to kill him. He had even identified a tree in Guru. And that's why I sympathize with you. Sometimes, sometimes these jobs, sometimes these jobs, I think we may need one time the late Professor Chidoma Kuya was asked to offer advice to the president, and he said in law you may or may give no advice. That's how he used to talk. In this case, I choose to give no advice. That's what he told the president. One of the reasons he was eventually sacked. What advice do you give to a person who has made the statements that the CDF has made? And then the president who went to Luwero to fight, killing people because he wanted the power. Yes, in Luwero they were not hunting, they were killing. He even speaks about it, how he was robbing guns from barracks, from Kabamba to Masindi to Hoima. He writes trouble is that you support him, but you don't read his book. Because if you did, all this information is there. He went to Luwero to kill, he killed, robbed the banks, including one in Kabale. And then he said he was fighting point number 1 of NRM is democracy. And he says judges don't rule. So who rules Uganda? The president and his son. That what they say is sacrosanct. Even the Attorney General, you are wasting your time. So when the Attorney General tells me understand whether you can render an advice to 2 military men who have already Mr. Speaker, the Constitution does not allow Parliament to take any decision whose effect will alter a judgment of court. In advising these military people who are not listening, the Attorney General said he was talking about an amendment. Can he tell us? And I listened to Honorable Fox Odoi very carefully, and I want to thank him. He said there's nothing to amend. But the Attorney General says they have advised him to amend. So what are you advising them to amend, sir? Thank you very much, Mr. Speaker.
Honorable Taylor John.
Thank you, Right Honorable Speaker. Right Honorable Speaker, the technical issues about the judgment have been raised ably. What I need to add, Right Honorable Speaker, is the component of human rights. In the whole world, when it comes to matters that affect human rights, there is always a deviation from deeper technicalities, because the feeling is that people's rights are being violated. And from the wording of the judgment, any continuation of detention of the prisoners infringes their rights. What the Attorney General has put, which we should put much emphasis on, is how should we do it systematically so that order is maintained in the country. It would also be ugly to wake up in the morning and then people say we have stormed the Luzira prison to pick our people. So what I want to implore the Attorney General is to rightly advise the powers that be to have an expeditious handling of the implementation of the non-debatable orders that were made in the judgment, considering in mind that we still have a long list of individuals who are now falling in the category of people whose rights have been violated. And at this point, we also need to appreciate the position of the Attorney General, where he is the legal advisor to government. And his role is advisory. So I see us crucifying a messenger who has delivered a message.
Thank you.
Thank you.
Attorney General.
Thank you very much, Right Honorable Speaker. I think I just want to clarify on one issue that probably Lop raised. The decision, the issue of the position of the inmates now, all the inmates who are under the trial in the General Court Martial, all their matters are now under the jurisdiction of the courts of judicature.
Just wait, Attorney General.
Yes.
Kindly,
Yes.
Honorable colleague, take your seat. Attorney General, continue.
Yes. So what I'm saying is that the court said seize these matters and transfer them to us. That means that the court, the Supreme Court, handed the jurisdiction over any matter that relates to any of those people to the courts of judicature. Now, Honorable Ssegona, we can continue the debate. I have rendered advice. I have told you that the government has decided to comply with the court orders, and we are going to comply with the court orders as have been given by the Supreme Court. I thank you.
Thank you. Thank you for that update. Attorney General.